If you have ever bought a firearm from a licensed dealer, whether at a gun store, a pawn shop, or a table at a gun show, you have filled out ATF Form 4473, officially called the Firearms Transaction Record. It is the form the federal government requires every time a firearm is transferred from a federal firearms licensee to a buyer. It is the paperwork that kicks off your background check through the National Instant Criminal Background Check System. Millions of these forms are completed every year. It is the most common piece of federal firearms paperwork in existence. And here is what most people sitting at that counter do not know. The crime is not completing the purchase. The crime is not even getting approved when you should not have been. The crime is making a false statement with intent to deceive. And that crime is complete the moment you finish filling out the form. Under 18 U.S.C. Section 922A.6, it is a federal felony to make any false statement in connection with a firearms purchase that is material to the lawfulness of the sale, up to 10 years in federal prison, up to a $250,000 fine, per false statement, not per transaction, per false statement. This video is for two audiences simultaneously. The first-time buyer who has never filled out a Form 4473 and wants to understand every question before they walk into a gun store. The second, the experienced gun owner who has filled out dozens of them but has never had anyone explain the legal exposure attached to each answer with the precision it deserves. By the end of this video, you are going to understand exactly what Form 4473 is, why it exists, what every section requires, what every eligibility question maps to in federal law, what happens after you sign it, and what the 5 most common mistakes cost the people who make them. Let me start with the foundation. Form 4473 exists because of the Gun Control Act of 1968. Congress required that every transfer of a firearm from a federal firearms licensee to a non-licensee be recorded and accompanied by a background check. The form is the mechanism for both. It records the transaction and triggers the NICS check simultaneously. The current version was revised in August 2023 and became mandatory for all FFLs on February 1, 2024. It has 5 sections labeled A through E. Understanding who fills out what and when is the first thing you need to know before you ever sit down at the counter. Section A is filled out by the dealer, not the buyer. It records the firearm information, make, model, caliber, serial number, and whether the firearm is a privately made firearm. The August 2023 revision added the privately made firearm designation specifically to address ghost guns entering the commercial market through FFL dealers. Section B is filled out by the buyer. It runs from question 1 through question 21N and covers your personal information and every federal eligibility question that determines whether you are legally permitted to receive the firearm. This is the section where all of the legal exposure lives. Every answer you give in Section B is a sworn statement under federal law. Section C is completed by the FFL after reviewing your government-issued photo ID. It records the NICS transaction number, the date the check was initiated, and the result: proceed, delayed, or denied. It also includes the FFL's certification that the NICS check is within 30 calendar days of the transfer. A NICS check is only valid for 30 days from when it was initiated. If the firearm is not transferred within that window, a new check is required. Section D is a recertification section, signed again by the buyer if the firearm is transferred on a different day than when Section B was originally completed. This happens when a NICS check is delayed or when a state waiting period applies. The buyer re-signs to certify that the information in Section B remains accurate as of the transfer date. Section E is the FFL's final certification that the transaction was completed in compliance with federal law. One additional point about Form 4473 that most gun buyers do not know: FFLs must retain all Form 4473 records for the life of their business. This rule changed in 2022 when the ATF extended the retention period from 20 years to permanent retention. The 4473 you fill out today stays on file at that FFL indefinitely and is available to law enforcement trace requests without a time limit. Now let me take you through Section B, because this is where the transaction is either legal or it is not. The personal information portion covers your full legal name, current residential address, date of birth, place of birth, height, weight, sex, and race or ethnicity. These are not questions with right or wrong answers in terms of your eligibility. But any deliberate falsification is a false statement on a federal form. Use your full legal name exactly as it appears on your government-issued photo ID, middle initial versus full middle name, hyphenated last names, junior and senior suffixes. Any variation between your Form 4473 and your ID causes a delay at minimum and can kick the NICS check out entirely. Question 10 asks about your country of citizenship. Non-immigrant visa holders, tourists, students on F1 visas, temporary workers on H-1B and similar visas are prohibited persons under 18 U.S.C. Section 922 G5. Your citizenship and immigration status determines whether you are even eligible to reach the eligibility questions. If you are in the country on a non-immigrant visa, the transaction cannot proceed unless you qualify for the narrow hunting or sporting exception the statute provides. The August 2023 revision also added 2 new questions to Section B that were mandated by the Bipartisan Safer Communities Act of 2022. Both target straw purchases and both carry significant legal exposure. The first, do you intend to purchase or acquire any firearm listed on this form for sale or other disposition to any person described in the prohibited person questions? The answer must be no to proceed. The second, are you acquiring the firearm on behalf of or at the request of any other person whom you know or have reasonable cause to believe is a prohibited person? The answer must be no. This question was specifically drafted to close the gap where a straw buyer purchases a firearm for a prohibited person and claims they did not know the recipient was prohibited. Reasonable cause to believe is the standard, not actual knowledge. Now let me take you through the eligibility questions. Questions 21A through 21N, because each one maps directly to a category of federal prohibition under 18 U.S.C. Section 922G, and each one carries the same federal perjury exposure if answered falsely. Question 21A is the actual transferee and buyer question, and it is the most commonly misunderstood question on the entire form. It asks, are you the actual transferee and buyer of the firearm listed on this form? The answer is yes if you are purchasing for yourself, even if the firearm is a legitimate gift for someone else. The answer is no only if someone else is paying for or directing the purchase, which makes the transaction an illegal straw purchase. This trips up gun buyers constantly. Someone purchasing a birthday gift for their spouse answers no because they are thinking, I am buying it for someone else. That is wrong. If you are the one making the purchasing decision using your own funds with no direction from the intended recipient about what to buy or where to buy it, you are the actual buyer. You answer yes. The form's instructions confirm the gift exception explicitly. The Supreme Court settled the straw purchase question definitively in Abramski v. United States, 573 U.S. 169, decided in 2014. Bruce Abramski, a former police officer, bought a Glock 19 for his uncle, Angel Alvarez, using his uncle's money, and checked the box on Form 473 indicating he was the actual buyer. Alvarez was legally eligible to buy a gun himself. Abramski argued that since his uncle was not a prohibited person, the lie was not material to whether the sale was lawful. Nobody was harmed, nobody was armed who should not have been. The Supreme Court rejected that argument 8-1. The misrepresentation prevented the dealer from running a background check on the real buyer, verifying his identity and confirming his state of residency. The lie itself was the crime, regardless of the recipient's eligibility. Straw purchasing under 18 U.S.C. Section 922A-6 carries up to 10 years in federal prison and a $250,000 fine. Prosecutors do not need to prove you knew the ultimate recipient was a prohibited person, only that you were not the true purchaser. Question 21B asks whether you are currently under indictment or information in any court for a felony or any other crime punishable by imprisonment for a term exceeding 1 year. Note the scope. Indictment alone, not conviction, triggers this prohibition during the pending case. Being charged is enough to bar a purchase while the case is active. Question 21C asks whether you have ever been convicted in any court of a felony or any crime punishable by imprisonment for a term exceeding 1 year. This maps directly to 18 U.S.C. Section 922 G1, the felon in possession ban covered in full, in this channel's dedicated section 922G, video. Any court means state courts, federal courts, and foreign courts. Punishable by means the maximum authorized sentence, not what you actually received. A felony conviction that resulted in probation and 0 jail time is still a conviction that requires a yes answer on this question. Question 21D asks whether you are a fugitive from justice, meaning there is an outstanding felony warrant for your arrest in any jurisdiction. An outstanding misdemeanor warrant does not qualify. The warrant must be for a felony. Question 21E asks whether you are an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance. This is the question at the center of the hemony ruling this channel covered in a dedicated video. Let me give you the compliance picture precisely. Marijuana remains a Schedule I controlled substance under the Federal Controlled Substances Act, regardless of your state's legalization status. The question asks about federal law. The ATF's January 22, 2026 interim final rule narrowed the regulatory definition of unlawful user. Isolated or sporadic use no longer meets the threshold under the revised regulation, but the statute itself is unchanged, and this question is still on the form. A yes answer on question 21E stops the transaction. And answering no while being a regular marijuana user is a false statement under 18 U.S.C. section 922A(6), carrying up to 10 years in federal prison, entirely separate from any prosecution under section 922G(3) for possession. The hemony ruling addressed the possession question under section 922G(3). It did not change the purchase form question under section 922A(6). Those are two different statutes with two different legal analyses. Question 21F asks whether you have ever been adjudicated as a mental defective or committed to a mental institution. This maps to section 922G(4). A voluntary psychiatric hospitalization does not qualify. A doctor's clinical diagnosis does not qualify. A formal legal adjudication, a court, board, commission, or other lawful authority finding that you are a danger to yourself or others, or that you lack the mental capacity to manage your own affairs, or an involuntary commitment ordered by a government authority is required. Question 21G asks whether you are an illegal alien or whether you are a non-immigrant alien. Non-immigrant visa holders answer yes unless they fall within the hunting or sporting exception. The question covers the section 922G(5) prohibition. Question 21H asks whether you have been discharged from the armed forces under dishonorable conditions. This maps to section 922G(6). Dishonorable discharge is issued only by a general court-martial. Bad conduct discharge does not qualify. Other than honorable discharge does not qualify. Question 21I asks whether you are subject to a court order restraining you from harassing, stalking, or threatening an intimate partner or child. This maps to section 922G(8). The domestic violence restraining order prohibition upheld 8-1 by the Supreme Court in United States versus Rahimi in 2024. The order must have been issued after a hearing with actual notice and an opportunity to participate. Not all restraining orders qualify. The three statutory elements must all be present. Question 21J asks whether you have been convicted in any court of a misdemeanor crime of domestic violence. This maps to section 922G(9), the Lautenberg Amendment category. A misdemeanor conviction involving the use or attempted use of physical force or the threatened use of a deadly weapon against a domestic partner triggers a lifetime federal firearms ban, even though the crime was a misdemeanor, even though it would not otherwise qualify under the felony conviction question, and even though the defendant may have served no jail time at all. Question 21K covers renounced citizenship under section 922G(7). If you have formally renounced your United States citizenship before a U.S. consular or diplomatic officer in a foreign country, the answer is yes. Question 21N asks two sub-questions added by the bipartisan Safer Communities Act: whether the buyer is under indictment for a crime of domestic violence, and, specifically for buyers between 18 and 20, whether the FFL may contact relevant juvenile justice authorities to verify the buyer's record. The under 21 sub-question reflects the expanded NICS review process for young buyers that the same legislation established. After answering every eligibility question, the buyer signs and dates Section B. That signature certifies that every answer is true, correct, and complete. That certification is the moment the federal obligation attaches. If any answer in Section B is false, the federal crime is complete at the moment of signing, not at the moment of transfer, not at the moment of receiving the firearm. Now let me walk you through what happens after you sign, the NICS background check, because this is where most gun buyers have the most practical confusion. After Section B is completed and the FFL has verified your government-issued photo ID, the dealer contacts NICS, the National Instant Criminal Background Check System, operated by the FBI's Criminal Justice Information Services Division. As of 2024, more than 92% of all NICS checks are processed through the FBI's online e-check system. 3 possible outcomes come back. Proceed. NICS found no disqualifying record in its databases. The FFL can complete the transfer. The buyer takes the firearm. In most cases, the result comes back within minutes. 2 critical nuances. First, a proceed means NICS found no disqualifying record at that moment. It does not mean you are definitively eligible to possess the firearm. NICS databases are not complete. Not every prohibited person's record has been submitted to the federal system, and a proceed from NICS does not insulate an FFL who has independent reason to believe a buyer is prohibited. Second, the FFL is not required to complete the sale after receiving a proceed. A proceed permits the transfer. It does not compel it. Delayed. NICS needs more time to investigate a possible disqualifying record. The transaction is neither approved nor denied. It is on hold while examiners research further. Federal law gives NICS 3 business days to respond. If 3 business days pass from the date the FFL initiated the check and NICS has not issued a denied status, the FFL is not federally prohibited from transferring the firearm. The dealer may proceed at their discretion. This is called the default proceed rule. That 3-day default proceed rule does not apply to buyers between the ages of 18 and 20. The Bipartisan Safer Communities Act of 2022 created an enhanced background check process for buyers under 21, requiring NICS to reach out to state juvenile justice agencies, mental health repositories, and local law enforcement to search for potentially disqualifying records that are not automatically in the federal databases. If NICS establishes cause for concern within the first 3 business days, the review period extends up to 10 business days before the default proceed clock begins. An 18 to 20-year-old buyer whose delayed check triggers the extended review cannot benefit from the 3-day default rule during that review period. Background checks that are delayed take longer for a reason. They are more than 4 times more likely to involve purchasers who were legally prohibited from buying firearms than checks that proceed immediately. A delay is not a bureaucratic inconvenience. It is an active investigation. Denied. A disqualifying record was confirmed. The dealer cannot transfer the firearm. Full stop. If a buyer believes the denial is erroneous, a false positive based on an incomplete or inaccurate record, they have the right to appeal through the FBI's NICS section by submitting fingerprints and identifying documentation so the examiner can verify whether the denial is based on an accurate match. False positives occur. The appeal process exists specifically to address them. What happens if a firearm was already transferred on a default proceed and the check subsequently resolves as a denial? The ATF may come to retrieve the firearm, and the buyer may face charges for false statements on Form 4473 if the denial reflects a genuine disqualification they concealed on the form. Now let me give you the 5 most common mistakes, because these are the errors that generate the most ATF compliance violations, the most delayed transactions, and the most federal criminal exposure. Mistake 1. Answering the actual buyer question incorrectly when buying a gift. The gift exception is real, explicit, and confirmed by the Supreme Court in Abramski. If you are genuinely buying a firearm as a gift using your own money and your own purchasing decision, with no direction from the recipient, you are the actual buyer. Answer yes. The error is answering no, because you are thinking about the gift recipient rather than who is legally making the purchase. Mistake 2. Using any name other than your exact legal name. Middle initial versus full middle name. A hyphen you include or exclude. Senior or junior that you omit. Any variation between Form 4473 and your photo ID causes a delay at minimum. Use your legal name exactly as it appears on the government-issued identification you hand to the dealer. Mistake 3. Using correction fluid or erasers on a completed form. If you make a mistake while filling out Section B, the correct method is to draw a single line through the error, write the correct information nearby, and initial and date the correction. Dealers are prohibited from using correction fluid or erasers on Form 4473. A form with whiteout on it is invalid. The FFL cannot proceed on it. A new form must be started from scratch. Mistake 4. Answering the drug user question based on your state's marijuana law rather than federal law. This is the mistake the Hamani ruling has made more common, not less, because the coverage of that ruling has been imprecise. Marijuana is a Schedule I controlled substance under the Federal Controlled Substances Act. The Form 4473 question asks whether you are an unlawful user of a controlled substance under federal law. Your state's legalization of recreational or medical marijuana does not change the federal classification. If you are a regular marijuana user and you answer no to question 21E, you have made a false statement on a federal form carrying up to 10 years, regardless of whether marijuana is legal where you live. The Hamani ruling addressed what the government can do to you for possession under Section 922G(3). It did not change what you are required to say on the purchase form under Section 922A(6). Mistake 5. Leaving any question blank. Every required field on Form 4473 must be answered. A blank field makes the form incomplete. The dealer cannot proceed until every question has a response. If you are unsure how to answer a question, ask the FFL for clarification before you sign, not after. Let me close with the compliance bottom line, the points that matter every single time you walk into a gun store. Every firearm purchase through an FFL triggers a Form 4473. There is no exception for gun shows, pawn shops, or informal retail settings. Any transfer from an FFL to a non-licensee requires the form. The obligation is the FFL's. They cannot complete the transfer without it, but the legal exposure for false answers is yours. The crime under Section 922A(6) is complete at the moment you sign a false answer, not when you walk out the door, not when you receive the firearm. The moment the pen leaves the paper after a false answer in Section B, the federal offense is complete. Understanding that timing changes how seriously you should treat every question on the form. And finally, the FFL's duty does not end with receiving a proceed from NICS federal law. 18 U.S.C. Section 922D makes it a separate offense for any person to transfer a firearm to any person knowing or having reasonable cause to believe the transfer is prohibited, even if the FFL has completed the background check requirements and received a proceed. A proceed from NICS is the floor of the FFL's legal duty. It is not the ceiling. An FFL who has independent reason to believe a buyer is prohibited cannot hide behind a NICS proceed. The form, the check, and the FFL's independent judgment are all part of the legal transaction. That is what every gun buyer needs to understand about ATF Form 4473. It is not routine paperwork. It is a sworn federal statement with federal criminal consequences attached to every answer.